Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights, okay? And basically we have been discussing the important facts and figures in the last lecture. So basically we will start from where we had left in the previous one. So we know that in the previous lecture, basically we were discussing upon the Article 16 and the reservation part of it. All right. And we had seen that basically in 1979, the second Backward Classes Commission appointed under the leadership of BP Mandal, right? And who was BP Mandal? BP Mandal was the parliamentarian, or you can say the member of parliament. That's why it is famously known as the Mandal Commission. Okay? And that commission was appointed by whom? Morarji Desai government. Okay? So in 1980, basically they had submitted their report and promised a 27% reservation for the OBC, or you can say the other backward classes. But we know that after the 10 years, in the 1990, when the BP Singh government was there, they implemented the 27% quota for the jobs, okay, for the OBCs. But then we know in 1991, Narasimha Rao government made two changes. Like they said, if they have to provide that 27% quota for the OBCs, the first preference will be given to the economically weaker section amongst them. Second thing they said, if someone belongs to the higher caste and economically backward, then they will provide the 10% quota if they are not covered under any schemes for the reservation. Then we know in the famous Mandal case 1992, the Supreme Court examined the 16th fourth, the Article 16th fourth in a proper manner and said that 27% is constitutionally valid, but the 10% is not so valid. Okay, so that are the things that we had discussed. And here we have just make a quick revision of it. So the reservation for the OBCs were allowed with the certain conditions. And what were these conditions? First is the advanced sections among the OBCs. It means the creamy layer should be excluded from the list of beneficiaries of the reservation. Okay, we know that basically in 2008, the Supreme Court propounded the concept of creamy layer in a well clearly defined manner. Okay, so that is also applicable here, like the creamy layer amongst the OBCs will be excluded from the list of beneficiaries from the reservation. Second thing, no reservation would be provided in promotions. Reservation would only be provided for the induction of service. Once the induction is made, then for promotion, no reservation would be provided. Reservation should be confined to the initial appointments only or the induction of service only. Any existing reservation in promotions can continue for 5 years only, like that judgment was passed in 1992, so till 1997. Thereafter, the total reserved quota should not exceed 50% except in some extraordinary situation. It means that for SC, ST, OBC, EWS, okay, if we combine all these ones, then the reservation part must not be crossing 50% of the seats, okay, except some extraordinary cases. This rule should be applied every year, okay. Thereafter, the carry forward rule in case of unfilled backlog vacancies is valid, but it should not violate the 50% rule. What does it mean? It means that suppose SC, ST, OBC and WS, the quota was provided, but the vacancies could not be fulfilled due to some various reasons. Okay, so suppose the 10% of the previous one is unfilled, and this year the government also provide the 20% reservation. So this 10% will be carry forward to this 20% and that will become 30%. So that is known as the carry forward rules. Means if due to some reasons the previous seats couldn't be filled, then the seats will be carry forward. But the 50% rule should be maintained at any cost. That could not be, you can say, changed or challenged. Thereafter, a permanent statutory body should be established to examine the complaints of over-exclusion and under-inclusion in the list of OBCs. Okay, it means that if government is, you can say, including them more and more, over-conclusion, that will be checked. If the government is putting them under the inclusion, it means that not including them in the proper sense, this should also be challenged. All right. So, with regard to the above rulings of the Supreme Court, the government has taken the following actions. First is, Ram Nandan Committee was appointed to identify the creamy layer amongst the OBC, and this committee submits a report in 1993 because the judgment was came out in 1992. Okay, and the report was accepted. Thereafter, another thing was there. The National Commission for Backward Classes was established in 1993 by an act of Parliament. Okay, it means that the dedicated commission for the backward classes was came into existence in the 1993, and that mandates was to examine the complaints of under-inclusion, over-inclusion, or non-inclusion of any class of citizens in the list of backward classes for the purpose of job reservation. Like the same thing was, you can say, demanded by the Supreme Court in their jurisdiction. Okay, and the similar thing would be implemented here by the help of National Commission for Backward Classes. Thereafter, later, the 102nd Amendment Act of 2018 conferred a constitutional status on the commission. Okay, it means that once the commission was established in 1993, all right, the commission was non-constitutional, or you can say basically was only statutory. But after the 102nd Amendment Act of 2018, that became constitutional body. Why? Because the constitutional status was provided to it. Okay? And because of the constitutional status, the functions also raised. For this purpose, the amendment inserted a new article, which is the Article 338B in the Constitution. All right. In order to nullify the ruling with regard to the reservation and promotions, the 77th Amendment Act was enacted in the 1995. Okay. It means that what the court said only the reservation could be made in the induction. It means once the person is inducted in the services, the person is not entitled to take any reservation with regard to the promotion because he belongs to certain caste, which is scheduled under the scheduled caste, scheduled tribes, or OBCs. Okay, so to change this, basically 77th Amendment Act was enacted in the 1995. And that added a new provision, Article 16, that empowers the state to provide for reservation in promotion of any services under the state in favor of the SCs, STs, and that are not adequately represented in the state services. It means that even after the induction, if the person belongs to scheduled castes, scheduled tribes, and his or her caste did not get adequate representation in the state services, then the person could be covered under the reservation for promotions. Okay. Again, there was an 85th Amendment Act of 2001 that provides for the consequential seniority in the case of promotion by virtue of rule of reservation for the government servants belonging to the SCs, STs with retrospective effect from June 1995. Okay. Thereafter, the ruling with regard to the backlog vacancies was nullified by the 81st Amendment Act of 2000, and basically it added another new provision in the Article 16 that empowers the state to consider the unfilled reserve vacancies of a year as a separate class of vacancies to be filled up in any succeeding year or years. Okay, it means that suppose 20% reservation was provided in 2001, but due to backlog, only 10% was filled. Okay, and then what happened? In 2002, the government had provided 41%, for example, 41% reservation. So if we take the carry forward rule, so this 10% will be added in this 40%, and what it will become? It will become 51%, which is exceeding the 50% rule, right? Okay, that was the reason why the government passed the 81st Amendment Act of 2000. Like it means instead of carried it forward, the government could do two changes. Like first, this 10% will be a separate class reservation, and this 40% will be the separate class reservation. All right, that's the thing. And you can say it is not necessary that this 10% which was provided in 2001 could only be included in 2002. No, any preceding years. It means that maybe it would be included in 2002, 3, 4, 5, 6, not fully or partially. Okay, so such vacancies are not be combined with the vacancies of the year in which they are being filled up to determine the ceiling of 50% reservation on the total number of vacancy of that year, which I have told you. In brief, it ended the 50% ceiling on the reservation in backlog vacancies. All right. Thereafter, the 76th Amendment Act of 1994 that has placed Tamil Nadu Reservation Act of 1994 in the 9th schedule to protect it from the judicial review, as it provided for 69% reservation for exceeding the 50% ceiling. So basically, if we talk about the 9th schedule, what was it? So basically, 9th schedule was added because of, or you can say first we must understand the judicial review. So we know the court having the power of judicial review to examine any resolution passed by legislatures or parliament to check their constitutional validity. Okay. So basically, to counter this thing, all right, on some provisions, first, Constitutional Amendment Act of 1915 was passed, okay, in which the ninth schedule was introduced. So what was this ninth schedule? If we talk about it, so we can say anything which has been transferred to ninth schedule, okay, any resolution on that matter couldn't be challenged in courts. Okay. So anything which has been transferred to ninth schedule, any resolution on that matter couldn't be challenged in courts. Okay. So that was the ninth schedule. So basically what happened here, like through the 76th Amendment Act of 1994, there was a bill, an Reservation Act in 1994. Please ignore this. Okay. Tamil Nadu Reservation Act 1994. So this act was also put under the ninth schedule so that it could get the immunity from the judicial review. Because here I have told you, if any matter and everything transferred to the ninth schedule, so any resolution would be passed on that thing could not be challenged in the courts under the power of judicial review. So similar thing was granted to it. All right. And why the government was trying to prevent it from being the part of judicial review? Because if you look at here, the act was provided the 69% reservation, and the court in the 1992 judgment already clarified that the reservation is not allowed to cross the boundary of 50%. Okay, and here you can see it was crossing. So that's why it was put under the ninth schedule. Thereafter, reservation for EWS in the public employment, if we talk about it in detail. So the above exception, D, was basically added by the 103rd Amendment Act of 2019. Okay. All right. This is the thing. So in order to give the provision effect, the central government issued an order in 2019 and providing the 10% reservation to the EWS or the economically weaker sections in the civil post and services in the government of India. The benefit of this reservation can be availed by the persons who belong to the category of EWS and who already are not covering under any reservation schemes running for scheduled caste, scheduled tribes, and the other backward classes. And what is the eligibility criteria? Laid down in this regard, we had already understood while we were understanding the Article 15. Okay. Further, the scientific and the technical post, which certifies all the following conditions can be exempted from the preview of this reservation. It means that the reservation could only be maintained in the administrative posts and the civil post. When this is the matter of commanding post, scientific post, and the technical posts, then no reservation criteria would be there. All right. The post should be in grades above lower grading group A of the services concerned. They should be classified as a scientific and technical in terms of the Cabinet Secretariat Order 1961, according to which the scientific and the technical post for which the qualifications in the natural sciences or exact sciences or the applied sciences or in technologies are prescribed, and the incumbents of which have to use that knowledge in the discharge of their duties. So for these provisions, or you can say for these posts, the reservation would not be provided. And the post for which you can say the qualifications required for conducting the research or for organizing, guiding and directing research, these posts will be out of the reservation criteria. After this, now we have the abolition of the untouchability. So this is provided by the Article 17 of the Indian Constitution. Article 17 of the Constitution abolishes the concept of untouchability and forbids its practice in any form. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with the law. Okay, so basically if we look at here, then the main thing was happened in 1976 when the Untouchability Offences Act 1955 has been comprehensively amended and basically getting renamed in the name of Protection of Civil Rights Act 1955. To enlarge the scope and make penal provisions more stringent. Like if we talk about the 1955 original act, so the original act had the narrow scope. Why? Because that was only governing the certain provision of the fundamental right provided under the Article 17. But when it was the year of 1976 and when the government amended the act and you can say enlarged the provisions, so basically they converted it to the protection of civil rights. It means that not only the provisions of the Article 17 but other provisions which are required to prohibit the practice of untouchability in the country, those provisions are also getting included in this provision. The Act defines the civil right as any right accruing to a person by a person of the violation of untouchability by the Article 17 of the Constitution. But here is the interesting facts and figures regarding this. Like if we talk about Article 17, so Article 17 is for the prohibition on untouchability. But the concept and the term of untouchability has not been defined either in the Constitution or either in the Act. It means we saying the Constitution and the Acts have been provided to stop the untouchability, but they themselves not carrying any term and even they are not defining any term as an untouchability. So how it works? So basically if we look at here, then there is a concept of Mysore High Court. So the Mysore High Court held that the subject matter of Article 17 altogether is not any untouchability in its literal or grammatical form. Because the article itself does not define anything as untouchable. So what happened? The practice which had been developed historically in the country, that was basically prohibited. And if we take it to the historical part of Indian history, then basically we have to deal with the ancient Indian history. Because that was in the ancient Indian history when the famous kingdom Gupta dynasty was existed. So during the time period of Gupta dynasty, the concept of untouchability came into existence for the very first time. So basically in the judgment, the Mysore High Court said that the act by itself does not define anything as an untouchable, but we consume the thing as an untouchable when it ensures the practice which had been developed in India historically. So basically it refers to the social disabilities which imposed on the certain caste of persons by reason of their birth in some certain classes. Hence, it does not cover the social boycott of a few individuals or their exclusion from the religious services and etc. in the name of untouchability. So the Supreme Court held that the right under the Article 17 is available against the private individuals and it is the constitutional obligation of the state to take necessary action to ensure that the right is not violated. It means that what happened to the certain class historically because they had been divided under the untouchable group, this must be stopped. Okay. Thereafter, now we have the Article 18, which is the abolition of titles. And this is also comes under the category of right to equality. Okay. So basically, the Article 18 abolishes the titles and make 4 provisions in that regard. Okay. Like it prohibits the state from conferring any title except the military or academic distinction on anybody, whether a citizen or a foreigner. It means the government cannot generate any title and cannot give any title to the anybody, whether the person is citizen or non-citizen, or you can say the foreigner. But the titles could be granted when it is the field of military actions and the academic distinctions. Thereafter, it prohibits a citizen of India from accepting any title from any foreign state. Okay, it means that no one in this country is allowed to take any title from any foreign state. Okay, and then if we talk about the third provision, which we could see here, is that any foreigner holding any office of profit or trust under the state, it means that under the government, he or she cannot accept any title from any foreign state without the consent of the President of India. Okay. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emolument, or office from any under foreign state without the consent of the President of India. So these 4 are the provisions on which the Article 18 prohibits the titles. From the above, it is quite clear that the hereditary titles of nobility, like the Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahab, Diwan Bahadur, etc. Like we know, when we talk about the history, then the history of the rulers. India was not the democracy since the starting. That's the fact that we are required to accept. All right. So basically, when the rulers were ruling the country and there were kingdoms, so it was, you can say, it was quite common that they adopted some hereditary titles like the Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahab, Diwan Sahab, etc. So, which were conferred by the colonial states. It means even the Britishers granted some titles to the Indians. All these are banned under the Article 18, as these are against the principle of equal status of all. Thereafter, in 1996, the Supreme Court upheld the constitutional validity of the national awards like Bharat Ratna, Padam Vibhushan, Padam Bhushan, and the Padam Shri. Okay, like if the government wants to give any of these titles and awards to the individuals, then they can give. Okay, ruled out, these awards do not amount to titles within the meaning of Article 18, for which the states are prohibited to confer the titles on the citizens. Okay, and Article 18 only prohibits the hereditary titles of nobility. Therefore, they are not violative of Article 18, as the theory of equality does not mandate that marriage should not be recognized. It means that only you want to give the equal status to all. So you will ignore those who are performing extraordinary. This could not be done. Okay. However, it also ruled out that they should not be used as suffix or prefix to the names of bodies. Okay. It means that suppose if someone got the Bharat Ratna, for example, and his name was Akash. So it is not allowed that he will use Bharat Ratna Akash was there. Okay. Or you can say as a prefix, or if we talk about suffix, so Akash Bharat Ratna. This could not be done. Okay. Otherwise, they should forfeit the awards. These national awards were basically instituted in the 1954 for the first time, but the Janata Party government headed by the Morarji Desai discontinued them in 1997. Again, they were revived in 1980 by the Indira Gandhi government. All right. So keep this thing in your mind. So students, basically in this lecture, we had finished till here. In the next lecture, we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture, and what we say thank you.